On July 11, 2025, 39-year-old Eric Littleton was arraigned in the 34th District Court in Romulus, Michigan, facing 3 felony charges: first-degree criminal conduct causing personal injury, third-degree criminal conduct through force or coercion, and larceny in a building. A preliminary examination was scheduled for July 30, 2025, in the courtroom of Judge Brian Oakley. As discussed in a previous episode of ATC, a preliminary examination in Michigan is a hearing held in district court after an arraignment in felony cases. Its purpose is to determine whether probable cause exists to believe that the defendant committed the alleged crimes. If the judge finds probable cause, the case is bound over to the circuit court for trial. Court records show that Mr. Littleton's attorney of record was James Earl King, Jr., a supervising attorney with the Neighborhood Defender Service, an indigent defense organization in Detroit. However, for the preliminary examination on July 30th, staff attorney Sahar Faraj appeared on his behalf in Judge Oakley's courtroom.
All right, appearances for People versus Littleton.
Morning, Honorable Step Moore, on behalf of the people, 84724.
Good morning, Your Honor. Attorney Sahar Faraj and Attorney Martin James Case, hearing on behalf of Mr. Littleton. Mr. Littleton, please introduce your
All right, ladies, we ready to go?
Yes, Judge, the people are ready to go, and I have a complaining witness who flew in from out of this country to be here today.
All right, put her on the stand.
Your Honor, I mean, Mr. Littleton, to refer the competency at this time, the defense counsel is adamant that Mr. Littleton is no way understanding the nature or the object of the proceeding and cannot. He is not fully aware, Your Honor, when I try to ask him or explain to him that I'm his attorney. He doesn't.
Let me stop you. When did you talk to him and realize you had those problems?
Well, it's been a compounded conversation. So what's the first one? It was a little off. If Your Honor was, I'm not sure if Your Honor was the judge at that time.
Was not.
Saying that I didn't think any.
Counsel, my question was a simple one. When did you know you had this problem?
So I'm telling you, it's a compounded issue, Your Honor. It wasn't just the first time; it was the second time also.
Denied. Denied. Twice I've asked you a direct question. You can't answer it. No, I asked you for a date. When did you know you had the problem? They flew somebody in from out of the country. If this was a problem you could have told them about a week ago, we could have avoided that. So we'll go ahead with the exam. You can do whatever you want. You can build whatever your record is. We're going to use the witnesses that are here today. I didn't ask for an argument, counsel. I just told you my decision.
Going to be completely. I think to be ready and what to be administered. Mr. Littleton had no opportunity to review the discovery. I'm not the attorney of record.
Then why are you here? Who's the attorney of record?
And that is correct, Judge, as much as Ms.
So schedule a show cause for Attorney King for contempt of court. Would somebody like to explain to me why the attorney of record is not here for a scheduled exam?
Understanding when it's a different matter that he's explaining to us because I was going to come here anyway, and because Mr. Littleton was going to refer to competency.
No, he wasn't. No, he wasn't. You were going to ask for that.
The court, the statute requires that the court at least consider the referral to competency at this point in time juncture. I understand that there has been a delay in the complaints from out of the country. However, the statute is very clear, and if Mr. Littleton cannot assist rationally not comprehend what is actually happening, actually he cannot move forward. And ultimately, the court has an obligation to consider.
Ms. Faraj informs Judge Oakley that she has concerns about Mr. Littleton's competency to stand trial. Courts have long recognized that subjecting a mentally incompetent defendant to criminal prosecution violates the Constitution. In the 1960 case of Dusky versus United States, the Supreme Court established the controlling standard for competency. A defendant must have sufficient present ability to consult with their lawyer with a reasonable degree of rational understanding, and must also understand the proceedings against them. Building on this, the 1966 case of Pate versus Robinson held that failing to provide a competency hearing when evidence of incompetence exists violates due process. Michigan law directly incorporates this constitutional principle. When competency concerns are raised in a pending proceeding, Section 330.2026 of the Michigan Compiled Laws requires the court to order a mental health examination of the defendant. Under Section 330.2028, the evaluator must submit a report to the court addressing whether the defendant is competent, and if not, whether there is a substantial probability that competency can be restored. The court then holds a hearing to determine competency after reviewing the report. Here, because competency was reasonably questioned, the court could proceed with the preliminary examination only to the extent allowed, meaning that testimony could not be taken from the witness who flew in from out of the country until Mr. Littleton's competency was determined.
Well, here's what I consider. Your office is continuing to do this to the court docket with attorneys that are scheduled, that don't show, don't call, just ghost us. We've got attorneys that show up the day of the exam having never spoken to their defendant repeatedly, day in, day out. Every Wednesday we have the same thing. Your office is disrespecting the Wayne County bench. Is that clear? We've been told we have to actually hold you people in contempt so that they can withhold the payment for the job that you're not doing. Would you like to say anything?
Judge, I just asked for an opportunity to make a fair record, if I may.
Go ahead.
So first of all, I would like to note that this is my first time actually working with Ms. Barrage. This is not, I believe, her choice. I believe she was sent here by Mr. King.
Oh, it sounds like they threw her to the wolves.
I just want to acknowledge that. I don't think that this is a problem for me.
No, she's just lucky enough to be the one I yell at. No.
Judge, I contacted Mr. King. I called NDS last week, contacted them specifically so that I could figure out ahead of the PCC who the defense attorney was. I found out that it was Mr. King. I contacted Mr. King. I got a hold of him that day. It was the day before the probable cause conference. I let him know that I was personally sending him the digital discovery so that he could review it. I indicated that there may be some competency concerns, and I asked if he would let me know if he would be referring for competency. I also let him know that I spoke to the out of the country complaining witness, confirmed that the next 4 to 6 Wednesdays were free in her schedule, and let him know that we would be flying her in, and told Mr. King that I would make any of those days work, but that if we scheduled an exam for her to be flown into the country, and Judge, this is very important, this happened at the airport, so flown into the airport, that she was sexually assaulted in, that if that happened, and if she came here, we were holding this exam, because I was not going to have the victim come all the way back here, only to be told that there was an adjournment request, or have him be referred for competency. I asked Mr. King that. I did feel at the time like he was dismissing me, but I also recognized it was pre-PCC. The PCC happened. I appeared early. I was not present when the actual date was set. It was set for 7 days out. We did everything that we could to get the victim here. I had the officer in charge meet her where her plane landed at the actual gate to get her from the gate through the airport. Again, she was sexually assaulted in to her hotel to keep her calm because she's been extremely traumatized as a result of this. Prior to this, after all the arrangements were made, I started calling Mr. King 48 hours before the victim needed to leave to come here, just to confirm that he was not planning on asking for an adjournment for discovery, to confirm that he was not planning on referring the defendant for competency. He refused to call me back, refused to answer my text. I got a call from him this morning at 8:30. It was the first time he has spoken to me since pre-PCC last week. And that is when he told me that he had not spoken to his client, that other members of his team had fortunately stepped in to speak to his client for him, and that they were concerned about his competency, and that he wasn't sure if the defendant would be able to sit through with this hearing today.
This is totally unconscionable.
The prosecutor explains that she attempted to contact Mr. King to determine whether he intended to raise the competency issue before arranging for a witness to fly in from out of the country for the preliminary examination, but he did not return her calls.
She also states that when she finally reached Mr. King that morning, he informed her that he had not spoken with his client. Mr. King's failure to meet with his client and attend the preliminary hearing raises several ethical concerns. Under Rule 1.1 of the Michigan Rules of Professional Conduct, lawyers must provide competent representation, which includes adequate preparation and proper handling of legal matters entrusted to them. Similarly, Rule 1.3 requires attorneys to act with reasonable diligence and promptness, and Rule 1.4 obligates attorneys to explain matters to their client to the extent reasonably necessary to allow informed decision-making. Accordingly, Mr. King's lack of communication with his client and absence from the preliminary hearing could be seen as potential violations of his professional duties of competence, diligence, and communication.
Which I told Mr. King that we would address the, because to be fair, Judge,
Mr. King better bring a toothbrush when he comes for the show cause. Please send that message. Clear? Counsel? Clear? Answer my question. Clear? Make sure he brings a toothbrush when he comes for his show cause. Thank you.
Judge Oakley warns Ms. Farage to tell Mr. King to bring a toothbrush the next time he comes to court, implying that he could be jailed for contempt. Under Section 600.1701 of the Michigan Compiled Laws, judges have the authority to hold attorneys in contempt for willful neglect, violation of duty, or disobedience of court orders, which can include missing a scheduled hearing. Additionally, Section 600.1711 allows judges to punish contempt with a fine, imprisonment, or both. Accordingly, Judge Oakley would likely be within his authority to hold Mr. King in contempt and impose jail time as a penalty.
if I may, Judge, I recognize I have no actual power to object to a competency referral. And I recognize that. But the way that this was handled, it is one thing to inconvenience me, and I have a lot of respect for the Neighborhood Defender Services. There are several of them here at this courthouse that I have so much respect for.
Me too.
But how this was handled was completely inappropriate, and I told Mr. King that until there was an actual issue in court, we were here, we were ready to go, and I'm at a loss, Judge, because ethically as a prosecutor, I know that I cannot push to proceed when there is a genuine referral for competency. I don't want to compromise my ethics, but this is extremely difficult for the position that we are in, and the reason we're in this position is because of Mr. King.
If I may, Your Honor.
Go ahead.
Well, thank you, prosecutor, for the procedural history, and I can't speak to the conversations of the prosecutor had with Mr. King directly. However, I will remind or just say that at the times and moments that Mr. King was stating that he did not intend to refer to competency until after buying over, that those were true statements, and it wasn't until understanding the actual, and not to get into privileged communications and client confidential conversations that we've had, that even at this preliminary examination, even if it is probable cause, and even though he's told the prosecutor that we don't intend to refer to competency until later, it was clear that Mr. Littleton has an issue understanding the order, nature, and proceedings, as well as not being able to assist rationally in his defense. So it's not to say that Mr. King wasn't being honest or truthful, but
He was being lazy and unprofessional, counsel. He never spoke to the defendant.
Your Honor,
Unless she's lying to me, King told her he'd never met with Mr. Littleton. Other people from his office had.
I wasn't part of that conversation. I can't speak to them. I'm not
Then I'm going to take her at her word.
lying. Just saying that all the other times that she was speaking with Mr. King and he made the applications and the intention of holding this exam, that was his intention. It wasn't to be dismissive. He wasn't refusing to communicate, that he was figuring out.
Counsel, stop, or I'll hold you in contempt.
Just trying to make my argument.
Keep talking, I'll hold you in contempt. I'm not going to let you make your argument because you don't know what you're talking about. You're not talking from firsthand knowledge. She is. Sit down. Counsel, don't test me. Sit down. You're done speaking today.
Done speaking today?
Yes, ma'am. Who flew in?
Judge, the complaining witness in this case, her name is Nora Al-Thamna, that's spelled N-O-U-R-A, last name A-L dash.
All right, I'm going to want her in here in just a minute. Do the paperwork so we can send Mr. Littleton for his competency, which will be 6 months down the road before we hear anything. You guys can take Mr. Littleton back into lockup. Bring your complainant in. Just podium, yeah. Right here, ma'am. Right here. Did you tell her what happened?
I did not. I told her that there was an issue and he wanted to see her and that I would explain after this.
So we're not going to have an exam today. I wanted to apologize to you personally for making you show up and put you through this and have nothing of substance happen. I also want to know exactly, with documentation to counsel, what it costs you to show up here today. Because if I find the attorney in contempt, I'm going to charge him for your costs. You understand that? All right. I just wanted you to hear it from me personally that I apologize on behalf of the system. I apologize to you because the system is not treating you well. Thank you, counsel. Was more anything else?
Thank you. And again, I just want to acknowledge that I do not believe that Ms. Farage did anything. She was just sent.
I don't disagree.
Instead of taking testimony, Judge Oakley ordered a competency evaluation to determine whether Mr. Littleton was mentally fit to stand trial. As of the date of this episode, the proceedings remain on hold pending the results of the evaluation, with a review hearing scheduled for October 15th, 2025. This hearing illustrates how scheduling pressures and lapses in communication can ripple through the courtroom. When an attorney has not met with a client or misses a critical proceeding, it causes delays in the case and leaves the defendant facing the proceedings without a clear understanding of the process or the charges against them. At the same time, such circumstances expose the attorney to potential consequences, including contempt or ethical violations. In the context of indigent defense, these difficulties often arise less from intentional neglect and more from overwhelming caseloads and competing demands. Nevertheless, the impact on both the court and the client is the same. The outcome here shows how a defendant's interests and an attorney's professional responsibilities are closely linked and how strained time management can lead to setbacks for both. Let us know in the comments if there's a case or courtroom interaction you'd like us to cover next. Thank you for watching, and don't forget to subscribe and share so that we can help foster a more informed society.